Okay, let's unpack this. Imagine diving into the very heart of how justice is administered in our society. From the gravest sentences right down to the fundamental right to liberty. Today, we're doing just that. Welcome to the Deep Dive, where we take these complex legal frameworks and try to transform them into clear, compelling insights for you.
Indeed. And our focus today is on two really crucial chapters of the newly enacted Bhartiya Nagrik Suraksha Sanhita 2023. BNSS for short, will be exploring Chapter X64, which covers execution, suspension, remission, and commutation of sentences. And then we'll get into Chapter XXE, dedicated to provisions as to bail and bonds. These sections are, well, they're truly the operational backbone of criminal procedure. They dictate what happens after a conviction and how liberty is managed before a trial concludes.
This isn't just about understanding a new law, is it? It's really about grasping the actual mechanisms that shape people's lives. The intricate safeguards built into the system, and sometimes the surprising nuances of how these laws are actually put into practice on the ground. Our mission today really is to cut through any perceived complexity and give you a comprehensive, but hopefully entirely digestible understanding of these critical aspects of our criminal justice system. So whether you're just inherently curious, maybe you're a student, or simply someone who wants to grasp the practical realities of how justice works, get ready for some truly illuminating moments. We're starting with perhaps the most solemn aspect of the law, the death sentence. When such a final judgment is passed, how does the system ensure it's carried out with, well, absolute precision and due process?
That's a profoundly important question. And it's precisely where Section 453 of the BNSS begins our journey today. This provision, it ensures that when a death sentence is confirmed or altered by the high court, it's actually the local court of session, the original trial court, that's tasked with implementing that final order.
Okay, so the high court reviews it, makes the ultimate call, but the sessions court is the one that handles the practical execution. Why split it up like that?
Well, it's a very practical arrangement, actually. Think of it this way. The high courts, they're appellate bodies, right? They review legal points, handle higher-level appeals. They're simply not equipped logistically to manage the day-to-day administrative tasks involved in carrying out executions across numerous districts. If they were, it would just bog them down, pull them away from their core roles of judicial oversight and interpreting the law. So, by delegating the physical execution to the Sessions Court, the system ensures that the High Court can remain focused on its critical appellate and confirmatory functions. It acts as the ultimate judicial arbiter, and its mandate is then precisely carried out by the relevant local court, the one closest to where the individual is actually held.
Right. That distinction makes a lot of sense. High Court sets the legal precedent, Sessions Court handles the ground-level stuff. Can you give us a concrete example of how this works in practice?
Certainly. Let's say the High Court confirms the death sentence for someone, let's call him X, who was originally tried in District Y. It's the Sessions Court of District Y that then issues the formal warrant of execution, sometimes called a black warrant. This warrant meticulously specifies the date, the place of execution. Now, on the flip side, if the High Court decides to reduce the sentence, maybe to life imprisonment, or even acquits the accused, then the Sessions Court issues the appropriate orders for imprisonment or release based on that High Court decision. The gravity of this whole process is something the Supreme Court has underscored many times. For instance, in Deen Dayal Upadhyay, way back in 1983, detailed guidelines were laid down, emphasizing humane procedures, respecting the condemned prisoner's rights, even at this final, very solemn stage.
Okay, that's how it works when the High Court confirms a sentence from a lower court. But what if the High Court itself, perhaps in an appeal, directly imposes a death sentence? Does the execution process change then?
That's a really insightful question, and Section 454 clarifies this exact scenario for us. Even when a death sentence is directly imposed by a high court, let's say they overturn an acquittal on appeal and convict someone, imposing the death penalty right there, it's still the court of session that remains responsible for its execution.
Really? So no matter which court ultimately pronounces or confirms a death sentence, it always funnels down to the local sessions court for the actual implementation.
Precisely. The high court, acting as an appellate or revisional body, generally lacks the direct physical infrastructure or personnel for carrying out executions. It's just not set up for that. So its order is communicated down to the relevant sessions court, typically the one where the original case started or perhaps where the accused is now located. That sessions court then takes on the responsibility and issues the necessary warrant for execution. This ensures a consistent, localized, and uniform procedure for all death sentences, irrespective of their judicial origin. It prevents any logistical gaps, and it maintains a clear separation between that high-level appellate review and the ground-level enforcement.
That makes the administrative chain of command incredibly clear. Okay, so the machinery for execution is well defined. But before that ultimate irreversible step, what safeguards are built into the system for a condemned person to challenge their sentence further?
That brings us to Section 455, which acts as a really crucial safety net in the legal process. This provision mandates the postponement of a death sentence's execution when an appeal to the Supreme Court is either pending or is actively being initiated. It's all about ensuring that every possible legal avenue is explored before an irreversible step is taken.
It sounds like the law places immense value on exhausting all legal remedies here. What makes this postponement absolutely mandatory? Is it automatic?
It's deeply rooted in the irreversible nature of a death sentence. This section ensures that an accused has every single opportunity to present their case to the highest court in the land. The High Court is legally obligated, duty-bound, to postpone execution in 3 specific scenarios. First, if an appeal to the Supreme Court is an absolute right, for instance, if the High Court reverses an acquittal and then imposes a death sentence itself, that's a direct route. Second, if an application for a certificate to appeal to the Supreme Court has been made, maybe on a significant point of constitutional law, something really weighty. And thirdly, and this is quite broad, if there's a clear intent to file a special leave petition, or SLP, under Article 136 of the Constitution. That's a discretionary power of the Supreme Court, remember.
Wow, so it's not just about an appeal being filed, but even the intent to file one can trigger this postponement. That's quite something.
It is indeed. It underscores a fundamental principle of due process in capital cases. No irreversible action should be taken while legal avenues, however slim they might seem, remain open. It implicitly acknowledges the possibility of judicial error, doesn't it? So, for example, if the High Court confirms Z's death sentence and Z's lawyer formally notifies the High Court of their genuine intention to file an SLP before the Supreme Court, the High Court, if satisfied that the intent is real and not just a delaying tactic, must postpone the execution for a reasonable period, often 60 to 90 days, giving them time to file. And if the SLP is subsequently filed within that time, the execution remains stayed until the Supreme Court makes a final decision on it. This aligns perfectly with what the Supreme Court itself said in cases like Shatrick and Shawn back in 2014. They emphasized exhausting all legal remedies, even judicial review of mercy petitions, before any execution.
Okay. Beyond these appeals, the law also makes specific humanitarian provisions. And this next section, Section 456, is quite striking, isn't it?
Absolutely. Section 456 reveals a powerful humanitarian clause. Its core concept is, pretty straightforward but profound. If a woman sentenced to death is found to be pregnant, the High Court shall commute her death sentence to life imprisonment. And note the word shall. This isn't a discretionary choice for the court. It's a mandatory legal directive.
Wow. So it's not about the severity of her crime or the conviction itself, but purely about the fact of her pregnancy and the life she carries. That's a profound ethical statement embedded in the law.
Exactly. It's a deeply humanitarian provision, primarily driven by the principle of protecting the life of the unborn child, yes, but it also reflects a compassionate approach towards the pregnant woman herself. The commutation becomes mandatory the moment the pregnancy is medically established, regardless of the merits of her conviction for the capital offense. This reflects a fundamental societal value that, even in the context of capital punishment for the most heinous crimes, the law prioritizes preserving innocent life. It really shows that our legal system isn't purely punitive. It's capable of integrating such deep ethical and moral considerations.
It's a powerful example. Okay, from the ultimate penalty of death, let's now turn our attention to the more common, yet equally impactful sentences of imprisonment. As you said, serving time isn't just about being behind bars. There's a whole complex administrative framework involved to ensure sentences are carried out correctly.
And that framework really kicks off with the state government's authority, which is detailed in Section 457. This provision basically grants the state government the power to designate specific places of confinement prisons, essentially for those imprisoned under the BNSS. It also covers the slightly more complex issue of transferring individuals from civil jails to criminal jails.
Okay, this sounds like a practical, almost administrative power.
Yeah.
How does the state government typically use this authority? What's the purpose?
It's primarily administrative, yes, but it's absolutely vital for efficient prison management. This flexibility allows state governments to manage their prison infrastructure effectively. They can allocate prisoners based on various factors, security levels needed, the available capacity in different facilities, or even specialized needs, like having dedicated facilities for women or high-security prisons for certain types of offenders. The transfer provisions are also key. They ensure that a criminal sentence takes precedence and is served appropriately, even if a person is already held in a civil jail, perhaps, for something like unpaid debt. It addresses those tricky scenarios where individuals might face both civil and criminal liabilities simultaneously.
Right, so it's not just about deciding where someone goes, but also managing these potentially complicated situations where different types of legal detentions overlap.
That's right. For instance, a state government might designate a central jail for long-term convicts, a district jail, perhaps more for those awaiting trial, under trials, and a sub-jail for shorter sentences. And if someone, let's call him P, is already in a civil jail for not paying a financial decree and is then convicted of a separate criminal offense, their criminal court can direct P to be moved to a designated criminal jail to serve that sentence first. After serving the criminal sentence, P would typically return to the civil jail unless, of course, other conditions for release from the civil liability have been met in the meantime.
Okay, so once the designated place of imprisonment is decided, what's the actual procedural step for sending someone to prison? How does that happen legally?
That's covered by Section 458. This provision meticulously details the formal procedure for executing sentences of imprisonment. It specifically requires the court to issue a formal warrant and then ensures the accused is forwarded, under guard, to the designated place of confinement.
So that warrant is the absolute key legal document here. It's the official permission slip, so to speak.
It is, unequivocally. This warrant is the foundational legal document authorizing that detention. It's far more than just a formality. It provides the specific and essential authority for the jail authorities to receive and lawfully hold a convict. Without it, any detention would simply be arbitrary and illegal. Full stop. The section also addresses practical scenarios, like when an accused is sentenced in their absence, maybe their attendance was dispensed with earlier. It clarifies that their sentence begins from the date of their eventual arrest, ensuring fairness in calculating the exact term served.
That's an important detail, ensuring fairness even if someone isn't physically present for their sentencing. What about very, very minor detentions? Does the law account for those?
Yes, the law even considers those situations. There's a provision for what's called imprisonment till the rising of the court. This allows for symbolic, very minor detentions, literally just until the court adjourns for the day without need for a full, formal jail warrant and the associated bureaucracy. So, for instance, if X is convicted and sentenced to 3 years of rigorous imprisonment, the court immediately prepares a formal warrant of commitment. If X was previously on bail, they are taken into custody right then and escorted to the designated jail with this warrant. But for very minor offenses, someone like Y might just be sentenced to imprisonment until the rising of the court. That means they're held, perhaps in the courtroom itself or a designated lockup, until the day's proceedings conclude, and then they're simply released. No need to go to a formal jail.
Okay, so the warrant is absolutely critical. But to whom specifically is this vital document addressed? And who is responsible for holding on to it within the prison system itself?
Sections 459 and 460 clarify these crucial procedural points. Section 459 specifies that the warrant for imprisonment must be directed to the officer in charge of the jail. And Section 460 then states that this warrant must be formally lodged with the jailer.
These sound like very granular, almost administrative details. Why are they considered so important in the broader legal framework? Why spell this out?
They are, despite seeming granular, absolutely essential for accountability. Directing the warrant to the officer in charge, who is typically the jail superintendent or the jailer, ensures that the legal authority reaches the person directly responsible for the prisoner's custody. No ambiguity there. Lodging it with the jailer then provides the immediate custodian of the inmate with the unquestionable legal basis for detention. This is paramount for maintaining accurate prison records, ensuring accountability, and preventing any confusion over legal authority. Without such clear procedural guidelines, you can imagine legal challenges to detention would become far more frequent and much harder to resolve.
Yeah, I can see how that attention to detail prevents any ambiguity and establishes a clear chain of command, a clear paper trail. Now, let's shift our focus from imprisonment to monetary penalties. When fines are imposed, how does the legal system ensure they are actually collected, especially if they aren't paid immediately?
That's precisely what Section 461 addresses. This provision offers courts two primary and quite powerful methods to recover unpaid fines. First, through the attachment and subsequent sale of the offender's movable property, things like cars, valuables, etc. And second, by authorizing the district collector to recover the fine amount as arrears of land revenue. This latter method is particularly potent because it can even extend to immovable property, like land or buildings.
Wow, so the court has some pretty strong tools in its arsenal to make sure fines get paid. What's the strategic thinking behind offering these two distinct methods? Why not just one?
Well, it's a pragmatic legal strategy, really, designed to ensure financial penalties aren't easily evaded. The direct attachment and sale of movable property is a relatively swift court-driven process, good for quicker recovery, perhaps. Involving the district collector, however, taps into a more robust and established state mechanism that's typically used for recovering public dues like unpaid taxes. This method gives the state broader powers, including that ability to attach and sell immovable property, which might be necessary for larger fines. Now, what's particularly important here is a key nuance, a proviso in the section. Generally, if an offender serves imprisonment because they couldn't pay a fine, the fine itself is usually considered absolved, wiped clean. However, and this is crucial, this rule doesn't apply if the fine or part of it was specifically set aside for victim compensation under another section of the BNSS or for other specific special reasons recorded by the court. This exception is vital because it ensures that victims don't lose out on their awarded compensation just because an offender served a default sentence instead of paying.
That's a really significant point. It tells us that the law is trying to prioritize making victims whole, even beyond the punitive aspect for the offender themselves.
Exactly. This dual-pronged approach ensures fines are effectively enforced. And that exception for victim compensation is a powerful recognition of sort of restorative justice principles operating within the broader punitive framework. It tells you that the law is seriously committed to compensating victims where possible. So, for example, if A is fined Rs. $50,000 and simply doesn't pay, the court could issue a warrant to seize and sell A's car. Alternatively, or maybe even additionally, it could send a warrant to the district collector. The collector then has the power to attach and sell A's land, for example, to recover the fine, treating it just like an unpaid land tax. And remember, if, say, Rs. $10,000 of that original fine was explicitly ordered as compensation to a victim, the court can still pursue that specific Rs. $10,000, even if A serves the default jail time. That principle was highlighted in the Remission case back in 2001.
You know, it raises an interesting practical question. What if the offender's property isn't actually in the same district as the court that imposed the fine? Can they just move their assets somewhere else to escape paying?
That's a very practical challenge the law anticipates. Section 462 directly addresses it. This provision clarifies that a warrant for fine recovery, specifically by attaching and selling movable property, can indeed be executed outside the issuing court's local jurisdiction. The key procedural step, though, is that it needs to be endorsed by the district magistrate, the DM of the area where the property is actually found.
Okay, so an offender can't just hide their car or other movable assets in another district to evade the fine. The warrant can follow them.
No, not at all. This provision is designed precisely to prevent offenders from doing just that. The endorsement by the local district magistrate acts as a formal validation, effectively empowering the local authorities in that new jurisdiction to execute the warrant. It's a vital procedural mechanism ensuring that financial penalties remain enforceable across different districts within the country. This kind of interconnectedness of judicial administration is crucial for effective enforcement in, a geographically diverse and mobile society like ours.
Right, okay. Beyond inter-district issues, what if a fine is imposed by a court in a territory where this new BNSS criminal procedure code itself doesn't fully apply? Maybe a special region. How do we ensure enforceability then?
That's where Section 463 comes into play. This provision allows warrants for fine recovery issued by criminal courts in Indian territories, where the BNSS might not directly apply, perhaps due to special constitutional provisions or local laws to be enforced in BNSS-governed territories. Essentially, these warrants are treated as if they were issued under the BNSS specifically for recovery as arrears of land revenue.
I see. So it creates a kind of legal bridge, ensuring fines can be collected across India, even if there are slight variations in the procedural laws applicable in different territories.
Precisely. This is a provision geared towards pan-India enforceability, specifically designed to bridge potential legal gaps and ensure that criminal sanctions aren't thwarted by minor territorial or legislative variations. By deeming such warrants as if they were issued under the BNSS for recovery as land revenue arrears, it provides a consistent and legally sound method for collectors in BNSS territories to recover fines imposed by courts operating under slightly different legal regimes within India. It really highlights the BNSS's broader intent for national uniformity in criminal procedure wherever possible, ensuring fines are paid no matter where they are imposed within the country.
Okay. But what if an offender simply needs a bit more time to pay a fine? Maybe they intend to pay but can't immediately, and they want to avoid going to jail for default. Does the law offer any flexibility there?
Yes, it does, and it's quite a compassionate and practical provision. Section 464. This section allows a court to suspend the execution of that default imprisonment term for unpaid fines. It essentially permits the offender to pay in installments or by a future, specified date, provided they execute a bond guaranteeing their appearance if they fail to pay.
So it's a way to avoid sending someone straight to jail just because they can't pay a fine up front. That sounds like a much more practical approach for genuine hardship cases.
It's both compassionate and practical, yes. Instead of immediate imprisonment for non-payment, courts can offer a structured payment plan. This helps genuine defaulters avoid jail by giving them time to arrange the funds, and importantly, it also helps reduce the burden on our already overcrowded prisons. The bond ensures that the offender remains accountable and will appear as required if they default on the payment plan. This provision actually extends to other monetary court orders that carry default imprisonment clauses, showing its broad applicability. It really shows how the law attempts to distinguish between an inability to pay and an unwillingness to pay, offering a pathway for the former while still retaining enforcement mechanisms for the latter. It's a neat balance between punitive action and a pragmatic flexibility.
That's a vital measure of flexibility.
Yeah.
It sounds like the law wants to give people a fair chance, especially if they're genuinely trying to comply.
Absolutely. For example, if B is fined Rs 5,000 with a default sentence of 1 month imprisonment, but simply cannot pay immediately, the court, using Section 464, might allow B to pay in 2 installments over, say, 60 days. They'd release B on a bond requiring appearance if payment isn't made. If B then defaults on those payments, okay, the 1 month imprisonment can then be executed. Courts, like the Patna High Court in the Palakdari-Melid case back in 1980, have affirmed this provision as a humane way for bona fide defaulters to avoid imprisonment.
Okay, that introduces a really important measure of flexibility. Now, let's maybe zoom out a bit to the general principles governing how all these different sentences, death, imprisonment, or fine, are actually put into effect and managed by the system. Beyond the specific types of sentences, there must be overarching rules that govern how they are all administered, ensuring continuity and order in the justice system, right?
And that's where Section 465 becomes very relevant. Its central idea is quite simple but essential. An execution warrant can be issued by either the original judge or magistrate who passed the sentence, or, equally validly, by their successor in office.
Okay, that sounds like a very practical, almost administrative rule. Why is that specific detail so important? Why mention the successor?
It's a crucial administrative continuity provision. Think about it. Judicial officers are frequently transferred or they retire. This section ensures that the execution of a sentence is never stalled or complicated simply because the original sentencing officer is no longer in that particular post. The authority to issue the warrant rests with the judicial office itself, not solely with the individual judge or magistrate who happened to hold that office at the moment the sentence was passed. This practical rule is absolutely essential for maintaining the efficiency of the judicial system. It implies that the integrity and authority of a judicial order, transcend the individual judge.
Yeah, I can imagine the massive backlog if every single warrant required tracking down the specific judge who originally passed the sentence.
Okay, so the who can issue the warrant is settled. But what happens if an individual tries to completely circumvent their sentence by escaping from custody?
Section 466 directly addresses that very scenario. Its core function is to determine how any new sentence imposed on an escaped convict will run in relation to their unexpired previous sentence. This provision ensures that an escape doesn't offer any kind of legal advantage or act like a reset button for their punishment. They can't benefit from running away.
Right, so an escapee can't just wipe the slate clean on their existing sentence by fleeing. That sounds like a pretty strong deterrent against escaping in the first place. Absolutely not. This section is specifically designed to prevent an escapee from benefiting from their flight. If the new sentence is for death, life imprisonment, or just a fine, that new sentence takes effect immediately. For term imprisonment, sentences for a specific number of years if the new sentence is severe in kind, meaning, for example, rigorous imprisonment compared to simple imprisonment, a distinction clarified in subsection 3. It also starts immediately. However, if the new sentence is not severe in kind, the convict must first complete the remaining portion of their original sentence before the new one begins. This ensures that punishment for the escape itself or for any new crimes committed while on the run is appropriately administered, without somehow nullifying the original sentence they were serving. It reflects the system's resilience, its determination to ensure justice is served despite attempts to evade it.
Okay, that makes sense for escapees. But what if someone is already serving a sentence and is then convicted for another, completely separate offense committed earlier?
Yeah.
How does the law manage multiple sentences in that situation?
That's the subject of Section 467. Its core principle establishes a general rule. Subsequent sentences of imprisonment will typically run consecutively, meaning one after the other, to any previous sentences the person is already serving. That's the default, unless the court explicitly directs them to run concurrently, meaning simultaneously. It also has special rules for those already serving life sentences.
Okay, so the default is basically to stack the sentences, one after another, serving the full time for each crime.
Yes. The default rule of consecutive sentences means an offender serves the full punishment determined for each distinct crime. However, courts do have discretion to order concurrent sentences. This discretion is often exercised after considering various factors. For instance, were the offenses part of the same transaction? Or would running the sentences consecutively result in a total sentence that is unduly harsh given the overall circumstances? Now, a significant nuance arises for life convicts. If someone is already serving a life sentence, any subsequent sentence, whether it's a term of imprisonment or even another life sentence, must run concurrently with the existing life sentence. This is because a life sentence is notionally considered to last for the remainder of one's natural life, so you can't really serve another sentence after that. There's also a proviso regarding imprisonment for a default of security, ensuring that substantive sentences for actual offenses are not delayed by these more procedural defaults. It really highlights the sometimes complex arithmetic involved in calculating criminal punishment, allowing for tailored justice.
It sounds like the courts have a really delicate balancing act when deciding whether sentences should run one after the other or at the same time.
They absolutely do. This provision is a crucial element in determining the overall effective period of incarceration for individuals who have multiple convictions. The court's discretion here allows for tailored justice, considering individual circumstances rather than just a rigid application of rules. For example, if A is serving a 2-year sentence and is subsequently sentenced to 3 years for an unrelated earlier offense, A's 3-year sentence will normally begin after the 2-year sentence is finished, unless the court specifically directs them to run concurrently. But if C is already serving a life sentence and is then convicted for another offense, receiving, say, a 7-year sentence, that 7-year sentence will run concurrently with the life sentence. It has to. The Supreme Court, in cases like Mot Akhtar Hussain back in 1988, emphasized that this discretion for concurrency must be exercised judiciously, based on sound legal principles.
You know, what's really fascinating here is how the legal system deals with these overlapping periods of detention, especially the time someone spends as an under trial in jail before conviction.
That's where Section 468 comes in, and it's an absolutely critical provision for fairness in the system. Its core principle mandates that any period of detention an accused has already undergone during the investigation, inquiry, or trial of the same case must be set off or credited, essentially, against their final sentence of imprisonment.
Wow, so time spent in jail just waiting for your trial to conclude actually counts towards the sentence if you're eventually convicted. That feels like a fundamental principle of justice, ensuring no one is punished twice for the same period of lost liberty.
Absolutely. This is a vital provision for fairness and, frankly, preventing excessive incarceration. It ensures that convicts receive credit for the time they've already spent in custody as an under trial. It applies to substantive sentences of imprisonment, and, importantly, this includes life imprisonment, a point clarified by legal precedent on the analogous section in the old CRPC. However, it does not apply to imprisonment served in default of paying a fine. That's treated separately. Crucially, this setoff also applies against that mandatory 14-year minimum actual imprisonment period required for certain life convicts under Section 475, which we'll discuss later. This ensures that pre-conviction custody is acknowledged even in the most serious cases. It directly addresses a common criticism of slow justice systems, ensuring that delays in trial, which might not be the accused's fault, do not unfairly prolong their total time incarcerated.
So time served really does mean time served, including the time before conviction. That's good to know.
Exactly. It reflects that fundamental principle of justice. No one should be punished twice for the same period of deprivation of liberty. It ensures that time served truly means time served. As an illustration, if D was arrested on January 1st, 2024, remained in jail as an under trial, and then on July 1st, 2025, is sentenced to 3 years imprisonment. The 18 months they already spent as an under trial will be set off. So D will only need to serve the remaining 18 months of the sentence. Similarly, if E is sentenced to life imprisonment in a case where Section 475 applies, requiring that 14 years of actual imprisonment, and E spent 2 years as an under trial before conviction, those 2 years will count towards meeting that 14-year minimum requirement. This principle was clearly upheld in the Bhartiya case by the Supreme Court back in 1985.
Okay. So what does all this mean for the overall calculation of sentences, especially when you have both substantive sentences and maybe those default imprisonment periods for not paying fines? Are there any specific rules there?
Yes. Section 469, which is titled Saving, addresses precisely these kinds of calculation issues. Its core idea clarifies, firstly, that the rules for sequencing sentences, for instance, for escaped convicts or those with multiple offenses running concurrently, do not somehow excuse or wipe away any part of the total punishment legally due. Secondly, it specifically prioritizes the serving of substantive sentences for the actual crimes over any imprisonment served in default of paying a fine when an individual faces multiple types of sentences.
Okay. So it's about making sure sentences are served in the correct order, the right priority, without inadvertently reducing the total punishment intended by the court.
Exactly that. Subsection 1 ensures that sequencing rules, like allowing sentences to run concurrently, don't accidentally reduce the total punishment legally due. It preserves the full measure of the sentence. And subsection 2 clarifies the order of serving different types of sentences. If someone has, say, a substantive sentence for crime A, then another substantive sentence for crime B, and also an imprisonment term hanging over them for default of paying a fine related to crime A, that default sentence is served only after both of the substantive sentences for crime A and crime B are completed. This is really a logistical rule designed to prevent minor default sentences from interrupting or delaying the serving of more significant punishments for the actual offenses. It maintains clarity and penal liability and ensures serious offenses take precedence in terms of actual time served.
That makes a lot of sense from a practical standpoint, preventing things from getting overly complicated or sequences getting mixed up in real-world prison administration.
Right. For instance, if Y is sentenced to 1 year imprisonment plus a fine of Rs 5,000 with a 1-month default imprisonment period for offense P, and Y also has to serve a separate 2-year sentence for offense Q, which starts after completing P's 1-year sentence, then that 1-month default sentence related to offense P will only commence after Y has served both the 1 year for P and the 2 years for Q, assuming the fine remains unpaid at that point.
Right, okay. So once all these sentences are eventually executed, fully served, how does the court get formal confirmation that its orders have actually been carried out? There must be some kind of official closure required for the court's records.
There absolutely is, and that's the precise purpose of Section 470. Its core concept mandates that the officer responsible for executing a sentence, usually the jail superintendent, must return the original warrant to the issuing court. And crucially, this returned warrant must have an endorsement on it, certifying exactly how the sentence has been fully executed.
So it's essentially about closing the loop, providing proof of execution, and maintaining accountability and proper records back at the court.
Precisely. This is a crucial procedural requirement for accountability and meticulous record-keeping. It effectively closes the loop on the court's original order. It provides formal, documented confirmation that its judicial mandate has been fulfilled, whether that's an imprisonment term fully served, a fine successfully recovered, or even in the gravest cases, a death sentence carried out. This ensures transparency and provides a formal audit trail for every single sentence imposed by the court, which is absolutely vital for maintaining the integrity and legal soundness of the entire justice system. For example, after a prisoner completes their term of imprisonment, the jail superintendent returns the original warrant of commitment to the sentencing court with an endorsement stating the date of release upon full service of the sentence. Similarly, after a death sentence is carried out, the jail superintendent returns the warrant with a certificate confirming the execution.
Okay. Finally, just wrapping up this section on general provisions, what about other monetary orders made by the court? Things that aren't technically fines, maybe costs or compensation? How are those recovered if someone doesn't pay?
Section 471 addresses this very point, providing a crucial default mechanism. Its core concept states that any monetary sum other than a fine which is payable by virtue of a court order under the BNSS, and for which no specific recovery method is provided elsewhere in the law, shall be recoverable as if it were a fine.
Ah, so it's a kind of catch-all provision. It ensures that all financial orders from the court are enforceable, even if they're not explicitly labeled as fines.
Exactly. It acts as a practical backstop. Courts often order various monetary payments besides fines, things like costs awarded to a complainant in a case or certain types of compensation. If the specific legal provision authorizing such an order doesn't outline a method for recovery, Section 471 steps in. It allows the court to use those well-defined fine recovery procedures we discussed earlier, like attachment and sale of movable property or recovery as land revenue arrears under Section 461. The proviso specifically links costs ordered in non-cognizable cases, for instance, directly to this fine recovery mechanism. And it even applies if default imprisonment is served, especially if the money was intended for victim compensation. This ensures that court orders for financial payments are never toothless. It's an important pragmatic catch-all, ensuring that all aspects of a judgment can be effectively enforced, thereby underpinning the overall authority of the judiciary.
Yeah, that makes a lot of sense. You wouldn't want a court order for costs or compensation to be essentially unenforceable just because it wasn't called a fine.
No, you certainly wouldn't. For example, if a court orders an accused to pay Ares 2000 as costs to a complainant in a non-cognizable case under Section 400 and the accused defaults, this amount can be recovered using the methods in Section 461, perhaps by attaching their movable property, precisely because Section 471 makes it recoverable as if it were a fine. The Allahabad High Court, way back in K.A. Abbas in 1978, discussed how this kind of provision creates a useful legal fiction for ensuring efficient recovery.
Okay, this rounds out the general rules for actually executing sentences. Now, let's pivot to something quite different but equally powerful in the justice system: the executive powers of mercy. We're talking about the suspension, remission, and commutation of sentences. While courts hand down sentences, there's this whole other layer of power: the executive branch's ability to show mercy or adjust sentences after the fact. This is really where politics and often humanitarian considerations can intersect directly with judicial pronouncements.
Precisely. And we begin this discussion with Section 472, which introduces a significant and quite new reform concerning mercy petitions, specifically in death sentence cases. Its core concept is to establish a structured, time-bound procedure for the filing and disposal of these mercy petitions for those on death row. These petitions go first to the governor of the state and then, if necessary, to the president of India. It also mandates joint consideration for co-convicts in the same case, and rather significantly asserts the finality of these executive decisions.
This sounds like a direct legislative response to some of the past criticisms and, frankly, the long delays that courts themselves have pointed out regarding the handling of mercy petitions.
It absolutely is. This is a significant codification aiming to bring much-needed order and expedition to a process that has, historically and often controversially, been plagued by delays. The Supreme Court, in the Shatrughan Chauhan case in 2014, for instance, even considered undue delay in deciding mercy petitions as a potential ground for commuting a death sentence to life imprisonment. So the legislature is clearly responding here. Key elements in this new section include specific timelines: 30 days for the convict to file the first petition after exhausting judicial remedies, 60 days to petition the president after the governor's rejection, and then 60 days for the central government to make its recommendation to the president. The mandate for joint consideration of co-convicts petitions also aims to ensure consistency and prevent potentially arbitrary or disparate outcomes for individuals involved in the very same crime.
Right, and what about that clause you mentioned, the one about finality and non-justiciability in subsection 7? That sounds like a really powerful assertion of executive authority, potentially limiting court oversight.
It is, and it's highly significant. Subsection 7 states that no appeal shall lie in any court against the president's or governor's decision on the mercy petition. And furthermore, it says that questions about the decision-making process itself shall not be inquired into by the courts. Now, this specific clause will likely face considerable constitutional scrutiny down the line. Why? Because courts have historically reviewed the process, though usually not the merits of mercy petitions. They've checked for things like arbitrariness, non-application of mind, or undue delay. Landmark cases like Maru Ram in 1981 and Kohar Singh in 1989 are prime examples of this judicial review in action. So this clause signals a clear legislative attempt to limit that kind of judicial oversight, which could indeed spark new legal challenges concerning the delicate balance of separation of powers and the scope of fundamental rights. It really highlights that inherent tension between executive prerogative and judicial review.
Yeah, it's certainly a critical balancing act there. Can you give us a quick example of how these new timelines would work in practice for someone on death row?
Certainly. Let's say X's special leave petition against a death sentence is dismissed by the Supreme Court. That's the end of the judicial road, essentially. The jail superintendent then formally informs X of this. X then has 30 days from receiving that information to file a mercy petition, typically starting with the governor of the state. If the governor rejects it, X then has another 60 days to petition the president of India. Once that petition reaches the president via the Home Ministry, the central government then has 60 days to make its recommendation to the president after considering comments from the state government and relevant records. And importantly, if A, B, and C are co-convicts in the same case, their mercy petitions, if filed, must be considered together by the president, ensuring a holistic and consistent approach to their fate.
Now, beyond death sentences, the appropriate government, which could be central or state, also has broader powers over other types of sentences. What's the scope of these general clemency powers?
That's primarily covered in Section 473. Its core concept empowers the appropriate government, which, again, could be either the central or state government, depending on the nature of the offense and which government's executive power extends to it, to do two main things. First, they can suspend a sentence, meaning temporarily hold it in abeyance. Second, they can remit a sentence, which means to reduce or waive the remaining part of it. And these actions can be done with or without specific conditions attached.
So it's not just the judiciary that has the final say on the length of a sentence. The executive branch also has a significant role in modifying sentences after conviction.
Yes, this is fundamentally an executive act, an exercise of sovereign power, often involving mercy or policy considerations. It's distinct from judicial review or appeal. Suspension, as I said, puts the sentence on hold temporarily. Remission reduces its quantum, the length of time to be served, without changing the fundamental nature of the punishment, like changing rigorous to simple imprisonment. That's commutation, which we'll get to. The government can attach conditions to suspension or remission, such as requiring good behavior, staying within certain boundaries, or reporting regularly to an authority. Now, while the opinion of the presiding judge of the trial court can be sought by the government to help inform its decision, they usually ask for it. That judge's opinion is not legally binding on the executive. The final decision rests with the government. This power really acts as a kind of safety valve in the justice system. It allows for flexibility in cases where someone has shown genuine reform, or due to medical emergencies, or even based on broader government policy considerations, like releasing prisoners on national holidays sometimes.
Right. It's an acknowledgement that the state's role can go beyond just punishment, potentially extending towards rehabilitation or recognizing changed circumstances. But it could be controversial too, right?
Absolutely. Its exercise can sometimes become controversial if it's perceived as being arbitrary or politically motivated. That's precisely why courts, like the Supreme Court in the Maru Ram case again, have held that even this executive clemency power must be exercised fairly and within a framework of reason, not just on a whim. For example, let's say A is sentenced to 5 years imprisonment. After serving 2 years with consistently good conduct, A applies for remission of the remaining sentence. The state government might consult the trial judge, review prison reports, and if satisfied, remit the remaining 3 years, either unconditionally or perhaps with conditions, like reporting to a parole officer for a certain period. Or, if B is released on suspension of sentence with a clear condition, say, not leaving the city limits, and then violates that condition, the government can cancel the suspension order. B can then be rearrested to serve the unexpired portion of their original sentence.
Okay, so remission reduces the sentence term. But what about changing the actual nature of the punishment itself? For instance, changing a sentence of rigorous imprisonment to simple imprisonment, or even life imprisonment, down to a term of years.
That's commutation, and it's covered by Section 474. Its core concept empowers the appropriate government to commute various sentences, which means changing them to a less severe form of punishment. Crucially, this can generally be done without the consent of the sentenced person, as it's typically seen as beneficial to them moving to a lesser punishment.
Right. So a death sentence could become life imprisonment, or a long term of rigorous imprisonment could become simple imprisonment for the same duration, or even a shorter term.
Precisely. Commutation involves substituting one form of punishment for another, less severe one. This is distinct from suspension, which is a postponement, and remission, which is just a reduction of the term. The section provides a clear, graded scale for how this works. A death sentence can be commuted to life imprisonment or another punishment. Life imprisonment can be commuted to a term of imprisonment, but importantly, not less than 7 years. A term of imprisonment of 7 years or more can be commuted to a term of not less than 3 years. Shorter terms of imprisonment can sometimes be commuted to just a fine, and rigorous imprisonment can always be commuted to simple imprisonment for the same or a shorter period. This power offers potentially a profound path for rehabilitation and an expression of state compassion. It allows for a reevaluation of the form of punishment itself, perhaps in light of changed circumstances, exceptional conduct, or evolving policy.
Those specific minimums you mentioned, like not less than 7 years for a commuted life sentence or not less than 3 years for a commuted sentence of 7 or more, are interesting. They seem like a way to balance mercy with ensuring that a certain minimum level of punishment is still served for serious offenses.
They absolutely are. These minimums are clear legislative efforts to strike that delicate balance. They ensure that while mercy can be shown by changing the type of sentence, a certain baseline of punishment remains for serious crimes. For example, the president or governor, guided by the section's principles, might commute a death sentence awarded to X to life imprisonment, or consider Y serving a life sentence. After many years of exemplary conduct and maybe showing complete reform, their life sentence might be commuted by the government to imprisonment for, say, 10 years. This is permissible because 10 years is not less than the statutory 7-year minimum specified for commuting a life sentence. The Supreme Court, way back in the Surat Chandrabha case in 1961, clearly defined commutation as substituting a less severe form of punishment for the one originally imposed.
Okay, while these clemency powers of remission and commutation seem quite broad, you mentioned earlier that the law also places some pretty strict restrictions in certain grave cases, specifically preventing early release for some life convicts.
Indeed. That's the very essence of Section 475. Its core concept mandates that certain categories of life convicts cannot be released from prison unless they have served at least 14 years of actual imprisonment. This applies specifically to those sentenced to life imprisonment for offenses where death was also a possible punishment, or those whose death sentences were previously commuted to life imprisonment.
Right. So even with the executive having powers of remission, there's a hard minimum period of time, 14 years, that must be served behind bars for these most serious categories of life sentences.
Yes, that's exactly right. This is a significant limitation on executive clemency powers, very similar to Section 433A of the older Criminal Procedure Code. It ensures a minimum foundational period of incarceration for individuals involved in the gravest offenses, effectively balancing the executive's power of mercy with the societal need for appropriate and significant punishment. And the 14 years here refers to actual time served in prison. Though, as we discussed under Section 468, any period spent in under-trial detention before conviction does count towards calculating this 14-year minimum. This provision reflects a very strong legislative policy intent, a clear signal that severe punishment is required for heinous crimes. It aims to prevent what might be perceived as premature release in cases that have deeply impacted society, ensuring a baseline period of retribution and deterrence. It acts as an important legislative check on the executive's clemency power, reflecting society's expectation for a substantial period of punishment in these cases.
So, for example, if someone is convicted of murder where death was a possible penalty, even if they get life imprisonment instead, or if their death sentence is commuted to life, they're still looking at a minimum of 14 years actual time served, regardless of remission possibilities.
Exactly. If A is convicted of murder, an offense where death is a possible punishment under the law and is sentenced to life imprisonment, or if A was sentenced to death and that sentence was later commuted to life imprisonment, then A cannot be released from prison through government remission or similar early release mechanisms unless A has actually served at least 14 years in jail, factoring in, of course, any time spent as an under trial before conviction. This principle was robustly upheld by the Supreme Court in the Maruram case back in 1981 regarding the analogous provision in the CRPC. It's a well-established restriction.
Okay, now speaking of these clemency powers, sometimes both the central government and the state government might have a role or interest in a particular case. How does that interplay work, especially in death penalty cases, which obviously carry such national significance?
Section 476 directly addresses this specific interplay in death sentence cases. Its core concept clarifies that the central government can also exercise the powers of suspension, remission, and commutation, specifically in cases involving death sentences, and it can do so concurrently with the state government.
So a death sentence case can effectively get reviewed for clemency at both the state level, by the governor, advised by the state government, and the national level, by the president, advised by the central government. That provides an additional layer of scrutiny, doesn't it?
It absolutely does. This provision establishes concurrent jurisdictions specifically for capital punishment cases, regardless of which government might ordinarily be considered the appropriate government under the general definition based on the offense, which we discussed under Section 473. It recognizes the unique gravity and national significance of death sentences and allows for intervention or consideration by either level of government. This aligns perfectly with the president's independent constitutional power of mercy under Article 72, which is always exercised on the central government's advice. This concurrent power essentially ensures an additional layer of review and potential clemency in death penalty cases. It also implies a kind of shared responsibility between the two levels of government in making these incredibly high-stakes decisions.
So, for instance, even if a state governor denies a mercy petition for a death row convict whose offense was under a state law, the president can still be approached, and the central government would advise the president on that petition.
Precisely. For example, if X is sentenced to death for an offense under a state law, like murder under the IPC-BNS, both the state government, advising the governor, and under Section 476, the central government, advising the president, possess the power to remit or commute X's death sentence. Typically, the process involves exhausting state-level remedies, first going to the governor. If that fails, the matter might then proceed to the president, who would be advised by the central government.
Okay, so the central government has concurrent powers, specifically in death cases. But in what other situations does the state government need to consult, or perhaps more strongly, get concurrence from the central government before exercising its own clemency powers?
That's the focus of the next section, Section 477. Its core concept mandates that the state government must obtain the concurrence. And that word is key. It's stronger than just consultation of the central government before exercising its clemency powers, suspension, remission, or commutation, in specific categories of cases that have a distinct central government nexus. This includes offenses that were investigated by a central agency, like the CBI or NIA, cases involving the misappropriation or destruction of central government property, or offenses committed by a central government servant in the course of their duty. It also covers complex situations involving concurrent sentences, where those sentences encompass both union, federal, and state offenses.
Right. This sounds like a crucial check and balance, particularly for cases investigated by central agencies or those that might have broader federal implications. It prevents states from unilaterally acting in ways that could affect central interests.
It is a key provision for ensuring cooperative federalism within our criminal justice system. It prevents unilateral state action that could potentially undermine central government investigations or broader national interests. It explicitly requires concurrence, not just consultation, for cases investigated by central agencies or those involving central property or personnel. And for those concurrent sentences that cover both union and state offenses, a state's clemency order for the state offense part will not actually take effect unless the central government also passes a similar order for the union offense part of the sentence. This ensures a coordinated approach and prevents partial releases that might undermine the overall sentence. This provision is a significant legal safeguard for the integrity of federal investigations and the protection of national interests. It helps avoid conflicts and ensures a coordinated approach to clemency in these complex, overlapping cases. The explicit use of the word concurrence rather than just consultation definitely strengthens the central government's hand in these specific matters, a point highlighted by the Supreme Court in the V. Sriharan case in 2016 regarding the analogous CRPC provision. It signals a legislative intent towards stronger federal oversight in these particular clemency scenarios.
Okay, that's been a truly deep dive into how sentences are executed and then potentially modified through clemency. Now let's explore the absolutely crucial provisions around bail, essentially, the promise of liberty before conviction. Bail is often a person's very first interaction with the criminal justice system, maybe even before they've spoken to a lawyer, and it's such a fundamental aspect of liberty. What's fascinating here, as we'll see, is how the law distinguishes quite sharply between different types of offenses and different circumstances when it comes to granting bail.
That's absolutely right, and Section 478 is fundamental to understanding this initial distinction. Its core concept establishes bail as an undeniable right for individuals accused of what are termed bailable offenses. For these offenses, bail is not a matter of judicial discretion. The section mandates their release if they are prepared to furnish the required bail. What's more, it includes a critically important provision for releasing indigent persons, those without financial means, on their own personal bond without needing sureties.
Okay, so for these bailable offenses, which are generally less serious, I assume, it's not really a question of if you get bail, but simply when and under what reasonable conditions, like the amount.
Precisely. For bailable offenses, and yes, they are typically less serious and are explicitly listed in the first schedule of the BNSS, the police officer making the arrest or the court before whom the accused is produced must release the person on bail, provided they offer to furnish it. The bail amount, of course, must always be reasonable. It shouldn't be set excessively high just to keep someone in custody. Now, the law actually offers a practical guideline here. If someone is unable to furnish a bail bond, usually meaning they can't find sureties, within 1 week of their arrest, that inability is considered sufficient grounds to presume they are indigent. This is a significant practical guideline, reflecting a vital commitment to ensuring justice isn't denied simply due to poverty. However, there's an important nuance. If a person has previously been released on bail in the same case and then failed to comply with the conditions of that bail, the court may refuse to grant them bail again on subsequent appearances in that specific case. This prevents abuse of what is otherwise a fundamental right. But that indigent person provision really demonstrates a legal recognition that poverty shouldn't equate to automatic pretrial incarceration. It aims to democratize access to pretrial liberty.
Yeah, that provision for indigent persons seems really important. It suggests the law is actively trying to prevent situations where poverty alone keeps someone locked up before they've even been convicted of anything.
Exactly. This principle was powerfully affirmed by the Supreme Court way back in the Modi Ram case in 1978. It's a crucial step towards ensuring that justice isn't just for those who can afford bail bonds and sureties. So, for example, if A is arrested for a bailable offense, A must be released on bail when produced before a magistrate, assuming A offers to furnish it. If B, accused of a bailable offense, is genuinely unable to find sureties for a required bail bond within a week of arrest, the court may and often should release B on their own personal bond without any sureties. However, flipping that, if C was previously released on bail for a bailable offense but repeatedly failed to attend court hearings, leading to their bond being forfeited, the court may then refuse to grant C bail again when they are brought back before the court in that same case.
Okay. Now, moving beyond these clearly defined bailable offenses, what about a critical safeguard against prolonged pretrial detention that's built into the system, even for people accused of more serious offenses?
This is the vital role played by Section 479. Its core concept mandates the release of under-trial prisoners, those held in custody pending trial on bail. Or, for first-time offenders, potentially just on a personal bond. This release becomes mandatory if they have been detained for a period extending up to 1/2 of the maximum possible imprisonment term for the offense they are charged with. For certain first-time offenders accused of offenses punishable with imprisonment up to 7 years, the threshold is even more lenient. Release is mandated after detention for 1/3 of the maximum possible sentence. Importantly, this provision excludes offenses that are punishable with death or life imprisonment. Those are handled differently. Crucially, it also caps the total period of under-trial detention at the maximum sentence prescribed for that specific offense. You can't be held as an under trial for longer than the maximum possible sentence upon conviction.
Wow. So you simply cannot be held indefinitely just because your trial is dragging on. That sounds like a really significant human rights protection embedded right in the procedure code.
No, you absolutely cannot, at least not for offenses below the level of life imprisonment or death penalty cases. This is a crucial safeguard against indefinite under-trial detention. It creates a presumptive right to bail after a substantial period of pre-conviction custody has passed, effectively balancing the state's legitimate interest in prosecution with the individual's fundamental right to liberty, especially when trials face delays. As you noted, first-time offenders get that more lenient 1/3 threshold, reflecting an even greater emphasis on protecting their liberty before conviction. The law also includes an explanation clarifying that delays caused by the accused themselves should be excluded when calculating these periods, which prevents defendants from deliberately stalling proceedings just to trigger this release provision. However, it's worth noting that this automatic release might not apply straightforwardly to those facing multiple distinct offenses or cases simultaneously. The interplay there can be complex. Significantly, the section also places a duty on jail superintendents to actively alert the court when prisoners under their charge reach these one-half or one-third thresholds, proactively ensuring these rights are protected.
Yeah, this whole provision feels like a very direct legislative response to long-standing judicial concerns about the problem of prolonged under-trial detention, which has been a real issue in the justice system for decades.
It is, very much so. This provision, or its equivalent in the older CRPC, is a direct legislative response to judicial concerns, notably raised in landmark cases like Hussein Khatoon back in 1980, which really shone a light on the plight of under-trials languishing in jails for years. It seeks to alleviate prison overcrowding and fundamentally uphold the constitutional right to a speedy trial. It's an aha moment that shows a system striving to ensure that justice delayed does not become justice denied by turning under-trial status into a form of de facto punishment before guilt is proven. So, for example, if X is accused of an offense punishable with a maximum of 6 years imprisonment, so not death or life, and X is a first-time offender who has been held in jail for 2 years, which is one-third of 6 years, X is entitled to be released on a personal bond unless the court, for specific recorded reasons, orders their continued detention, which would be unusual. If Y, who is not a first-time offender, is in jail for 3 years, which is one-half of 6 years, for the same offense, Y shall be released on bail. And as mentioned, the jail superintendent plays a critical role by formally making the application to the court for the prisoner's release when these time limits are reached.
Okay. But what happens in those non-bailable offenses, where bail isn't a right, but purely a matter of the court's discretion? The stakes are obviously much higher there, and the considerations must be different.
That's where Section 480 becomes absolutely pivotal. Its core concept governs the discretionary grant of bail in non-bailable offenses, whether by a magistrate or a police officer, in limited circumstances. It meticulously outlines the conditions under which bail might be granted or refused, the restrictions that apply, and importantly, it includes specific provisos for vulnerable groups and certain situations.
Right. So, unlike bailable offenses, the court here has to actively weigh many different factors. It sounds like a much more complex decision-making process.
Absolutely. Bail here is entirely discretionary, requiring careful judicial consideration of all relevant factors. The section imposes strong presumptions against granting bail for very serious offenses specifically, those punishable with death or life imprisonment if there appear to be reasonable grounds for believing the accused committed such an offense. It also restricts bail for certain repeat offenders. However, critical provisos temper these strict restrictions. Bail can still be granted, even in these serious cases, for vulnerable categories like children under 16, women, or the sick and infirm. Or the court can grant bail for any other special reasons, which it must record in writing. For these serious offenses, death-life penalty cases, giving the public prosecutor an opportunity to be heard before granting bail is mandatory. Subsection 3 lists mandatory conditions that must be imposed if bail is granted for certain grave offenses, those punishable with 7 years or more, or certain specific chapters of the BNS. These conditions typically include attending court, not tampering with evidence, not inducing witnesses, etc. This reflects that delicate balance between individual liberty and public safety. And here's another crucial speedy trial provision embedded within this section. If a non-bailable case being tried by a magistrate is not concluded within 60 days from the date fixed for taking evidence, the accused shall be released on bail unless the magistrate, for reasons to be recorded in writing, decides otherwise.
Wow. That 60-day rule for magistrates trying non-bailable cases is another powerful incentive for efficiency in the trial process. It suggests the system is actively trying to prevent indefinite delays even in these more serious but magistrate triable cases.
It truly is. This section represents a careful calibration by the legislature, attempting to prevent the arbitrary denial of liberty while simultaneously safeguarding society from potentially dangerous offenders. This is precisely where the court weighs all of those crucial factors: the nature and gravity of the accusation, the severity of punishment, the risk of the accused fleeing justice, the potential for evidence tampering or witness intimidation, the accused's character and community ties, and so on. These are the kinds of factors laid down in landmark Supreme Court judgments like Gurcharan Singh in 1978 and more recently Sanjay Chandra in 2012, which emphasize that prolonged deprivation of liberty before conviction is itself a significant factor for courts to consider when deciding bail. So, to illustrate, if X is accused of a non-bailable offense punishable with, say, 5 years imprisonment, a magistrate may grant bail after considering factors like X's community ties, lack of prior record, and perceived risk of abscondence, recording the reasons for granting it. But if Y is accused of murder, punishable by death or life imprisonment, a magistrate generally won't grant bail unless Y falls into one of those specific exceptions, perhaps being gravely ill or a child under 16. And if Zio, who is on trial before a magistrate for a non-bailable offense, has been in custody for over 60 days since the first date fixed for evidence and the trial is still dragging on, Z shall normally be released on bail unless the magistrate has very specific compelling reasons, which they must record, for not doing so.
Okay. Once bail is granted, whether for a bailable or non-bailable offense, what steps are taken to ensure that the accused remains available for further legal proceedings, especially if the case goes up to higher courts on appeal?
That's where Section 481 comes into play. Its core concept requires the trial court or the appellate court, right before concluding the case, like delivering a judgment of acquittal or conviction, to make the accused execute a specific type of bond. This bond is designed purely to ensure their appearance before the next higher appellate court if an appeal or petition is filed against the judgment by the other side, the state or the complainant.
So it's about anticipating potential future appeals and ensuring the accused doesn't simply vanish off the radar if a lower court decision goes in their favor, only for that decision to be challenged later.
Precisely. This provision, which is similar to Section 437A in the older CRPC, is a practical procedural measure. It's designed to prevent the difficulty and sometimes impossibility of securing an accused's presence months or years later after an acquittal or a favorable appellate judgment, should that judgment be challenged further up the judicial hierarchy. The bond typically remains in force for 6 months, which covers the usual initial limitation period for filing most appeals. If an appeal is filed and notice is issued by the higher court within that period, the accused is obligated to appear. Failure to appear would then lead to forfeiture of this specific bond. This foresight built into the legal process ensures the efficiency of the appellate system. It prevents accused persons from simply disappearing once a favorable lower court decision is rendered, and really highlights the idea of justice being a continuum through various judicial tiers.
Okay, that makes sense. Now, beyond regular bail granted after arrest, many people are familiar with the concept of anticipatory bail getting protection before an anticipated arrest. How does the BNSS frame this critical pre-arrest protection?
This is a very significant area covered by Section 482. Its core concept empowers the High Court or the Court of Session to grant what's commonly called anticipatory bail. This essentially means the court directs that if a person who has reason to believe they may be arrested on accusation of having committed a non-bailable offense is arrested, they shall be released on bail immediately. Now, crucially, this section in the BNSS now includes specific exclusions for certain grave sexual offenses defined under the new Bhartiya Nagrik Sanhita 2023, or BNS. This is a major change.
Right, so anticipatory bail is for when you genuinely anticipate an arrest, maybe based on an FIR being filed, but haven't actually been taken into custody yet. What are these new exclusions and how significant are they? This sounds like a really big development in this area of law.
Indeed, it's very significant. Anticipatory bail has always been seen as an extraordinary pre-arrest remedy, allowing individuals to seek protection from potential harassment, humiliation, or unjustified detention. The court exercises wide discretion here, considering factors like the nature and gravity of the accusation, the applicant's antecedents, past conduct, the possibility of them fleeing justice, and the risk of evidence tampering. Conditions are always imposed if anticipatory bail is granted, primarily to ensure cooperation with the ongoing investigation. Now, for the crucial part. Subsection 4 introduces a new and highly significant restriction. It explicitly states that the provisions of this section, granting anticipatory bail, shall not apply to certain offenses. Specifically, it excludes offenses under Section 65 of the BNS, which deals with sexual intercourse by a husband upon his wife during separation where consent was obtained by deceit or false promise of marriage. And it also excludes Section 72 of the BNS, which concerns the horrific crime of gang rape on a woman under 18 years of age. This marks a very deliberate legislative choice to adopt a much stricter stance on pre-arrest bail for these specific, grave sexual offenses. It reflects a heightened focus, clearly, on victim protection in these particular contexts.
Wow, that's a major shift in the law's approach. How is this likely to impact the delicate balance between protecting victims and upholding the rights of the accused to seek pre-arrest liberty, especially given past court rulings that favored broad discretion?
It's a profound change, and its impact will unfold over time. The exclusion for these specific offenses will undoubtedly reduce, or rather eliminate, the avenue of pre-arrest protection for those accused of these particular crimes. They simply cannot apply for anticipatory bail under Section 482. This raises an important question for future jurisprudence. How will the courts interpret and apply this? How will the balance between victim protection and the rights of the accused to pre-arrest liberty be recalibrated in practice, especially considering landmark judgments like Gurbakh Singh Sibia back in 1980, which generally favored broad judicial discretion in granting anticipatory bail? This new exclusion signals a very strong legislative intent to prevent any potential misuse of anticipatory bail in these extremely sensitive cases, prioritizing victim safety and the integrity of the investigation from the very outset. So, for example, Pira case believing Q has filed a false FIR alleging a non-bailable offense, like cheating perhaps, can apply to the Court of Session for anticipatory bail. The court, if satisfied after considering the factors, may grant it with conditions like cooperating with the investigation. However, if R is accused under Section 72 BNS for gang rape on a minor, R cannot apply for anticipatory bail under Section 482 BNSS. That door is now statutorily closed due to the specific exclusion in subsection 4.
Okay. Building on anticipatory bail, the higher courts, the High Court and Court of Session, also have special, broader powers when it comes to granting regular bail post-arrest. And you mentioned there are new vital provisions concerning victims in certain offenses here, too.
That's Section 483, yes. Its court concept confers wide discretionary powers upon the High Court and the Court of Session regarding bail matters generally. This includes the power to grant bail to any person in custody, even if a lower court refused it, the power to modify conditions previously imposed on bail, and the power to cancel bail if it's being misused. Now, significantly, this section also introduces specific notice requirements for the public prosecutor and, quite radically, mandates victim participation in bail hearings for those same serious sexual offenses under the BNS that we just discussed regarding anticipatory bail.
Right. So not only do the higher courts have more flexibility than magistrates in granting regular bail, but now, for these specific serious sexual offenses, victims or their representatives must be present during the bail hearing. That sounds like a profound shift, giving a direct voice to those most affected at a critical pretrial stage.
It certainly is a landmark change. The powers of the High Court and Court of Session regarding bail are indeed wider than those of magistrates. They are not bound by some of the stricter restrictions placed on lower courts, for instance. The general bar against bail for offenses punishable with death or life imprisonment if reasonable grounds exist to believe the accused is guilty. Higher courts can still grant bail in such cases if they deem it fit, using their broader discretion. They can grant bail where a magistrate might have refused. They can modify conditions imposed by a lower court if they seem overly harsh or unnecessary. Or they can cancel bail entirely if the person released on bail violates conditions or tampers with justice. Now, what's truly revolutionary here, as you noted, is the introduction of this new victim-centric reform within Section 483. For bail applications related to those specific offenses under Sections 65 and 72 of the BNS, when the application is before the High Court or Court of Session, the court must give notice to the public prosecutor within 15 days of the application being filed. And, crucially, the presence of the informant, often the victim or their family, or their authorized representative shall be obligatory at the bail hearing itself. This aims squarely at preventing potential re-victimization and ensuring that the concerns and perspective of the victim are heard directly by the court before it makes a decision on the accused's liberty. It could significantly shape future jurisprudence on bail in these sensitive cases. This mandatory presence could empower victims and fundamentally transform the dynamics of bail hearings in these specific contexts. It raises an important practical question, though. How will courts effectively balance the rights of the accused with the newly mandated presence and voice concerns of the victim or informant during these hearings? That will be key to observe.
Absolutely, that's a huge development. So just to be clear, for example, if someone is accused of gang rape on a minor under Section 72 BNS, and they apply for regular bail to the Sessions Court, the prosecutor must be notified within 15 days. A&D, the victim or their designated representative must be present in court for that bail hearing.
Yes, that's precisely what the law now requires for those specific offenses under Section 483. Their presence is obligatory. To illustrate the other powers under 483, if A is accused of a non-bailable offense and a magistrate refuses bail, A can still apply to the Court of Session or the High Court for bail under Section 483(1). That higher court will consider the application on its merits using its broader discretion. If B is granted bail by a magistrate but with an overly harsh condition, like an impossibly high bond amount, B can apply to a higher court under Section 483(1) to have that condition modified. And if C, once released on bail, starts threatening witnesses, the prosecution can file an application under Section 483 on C seeking the cancellation of C's bail.
Okay, so the higher courts have these expansive powers powers, now including these new victim-centric safeguards for specific offenses. But shifting gears slightly, how does the system ensure the financial aspects of bail, the bonds themselves, are fair and effective? Because bail isn't just a decision, is it? It's effectively a contract, a promise, backed by a monetary bond or surety. And the rules for these bonds must be just as intricate as the decisions to grant bail in the first place.
That's absolutely right. And Section 484 directly addresses the financial aspect. Its core concept mandates that the amount of any bail bond must always be fixed reasonably, taking into account the specific circumstances of the case. Crucially, it explicitly states that the amount should not be excessive. It also specifically empowers the High Court or the Court of Session to reduce bail bond amounts that might have been set too high by lower authorities, like a police officer or a magistrate.
Okay, so the goal here is really to prevent bail from becoming an instrument of injustice, effectively denying liberty simply because someone doesn't have significant financial means. It shouldn't be punitive.
Exactly. This provision is designed to prevent bail from becoming a punishment in itself, particularly for the poor. The phrase, circumstances of the case, is interpreted broadly to include factors like the nature and seriousness of the offense, certainly, but also the accused's financial status, their roots in the community, and the perceived risk of them absconding. The power of higher courts to reduce bail amounts acts as a vital check against potentially unreasonable or punitive conditions imposed by lower courts or the police. It really embodies the principle that bail should primarily aim to secure the accused's presence for trial, not to punish their poverty. As Justice Krishna Iyer famously remarked in the Modi Ram case, bail amounts should not be set as fancy sums, but should be reasonable figures realistically calculated to secure attendance. It's an aha moment connecting legal theory to the practical realities faced by an accused. For example, if a magistrate sets a bail bond of, say, 5 lakhs for an accused person of very modest means in a relatively minor, non-bailable case, that accused person can apply to the Sessions Court or the High Court under Section 484 to have this amount significantly reduced to a more reasonable sum, citing their financial inability.
Right. The amount is obviously important. But what are the formal requirements for actually executing these bonds? And what specific obligations do the sureties, the people who guarantee the bond, undertake?
Section 485 details this meticulously. Its core concept outlines the formal execution process for bonds, both the personal bond executed by the accused themselves and, if applicable, the separate bonds executed by sureties. These bonds legally condition the accused's attendance in court on specified dates and their adherence to any other specific conditions imposed by the court as part of the bail order. It also explicitly grants courts the authority to actively verify the fitness and sufficiency of any proposed sureties.
Okay, so a bond is a formal legal agreement with very clear terms and consequences if breached.
Yes, precisely. A bond is the accused's own personal undertaking, their promise to the court. A bail bond involves that additional layer of guarantee from sureties who essentially become financially liable for the bond amount if the accused defaults on their conditions, like failing to appear. The bond's primary condition is always attendance when required by the court, but it must also incorporate any other specific conditions imposed by the court. Common examples include not tampering with evidence, not contacting specified witnesses, surrendering their passport, etc. The court has a duty, under this section, to ensure that any sureties offered are sufficient, meaning they appear financially capable of covering the bond amount if forfeited, and also fit, meaning they seem reliable and trustworthy enough to actually ensure the accused's compliance. Courts can conduct inquiries to verify this, including asking for affidavits from the sureties regarding their financial status and assets. This formalization ensures absolute clarity of obligations for everyone involved and provides a clear legal basis for enforcement if the conditions are breached later. The inquiry into sureties is vital to prevent sham guarantees and maintain the overall effectiveness and credibility of the bail system.
So, for example, if a person is granted bail with a surety, the court can actually probe a bit, check if that surety is genuinely able to cover the bond amount if things go wrong.
Exactly. If X is granted bail on, say, a personal bond of Rs. 20,000, with 2 sureties also providing bonds for Rs. 20,000 each. X executes the personal bond, and the 2 sureties also execute their separate surety bonds before the court or authorized officer. These bonds will clearly specify the required attendance dates and any additional conditions imposed, such as X shall not contact witness W. The magistrate might then reasonably request affidavits from the sureties regarding their financial capacity, maybe asking about property they own or their income, to satisfy themselves of their sufficiency.
Okay. And to further strengthen that surety system, you mentioned there's a specific requirement now for sureties to declare their existing commitments. That sounds like it's directly aimed at weeding out those professional sureties or individuals who might be standing guarantee for too many people at once.
Precisely. That's the purpose of Section 486. Its core concept requires every person who offers to stand as a surety in a case to make a formal declaration to the court. This declaration must state how many other accused persons they have previously stood surety for, including details of those cases and the amounts involved. It also requires them to state if they are currently surety for the present accused in any other case. This provision aims squarely at preventing the problem of professional sureties, individuals who make a business out of it, or simply people who are financially overextended and cannot realistically fulfill their obligations if multiple accused persons abscond. By requiring this declaration, the court gains a much clearer picture of the proposed surety's existing commitments and potential liabilities. This helps the court assess their suitability and capacity to genuinely ensure the current accused's appearance more effectively. It's a relatively simple procedural step, but it adds a significant layer of transparency and accountability to the surety system, making it more robust against potential abuses and ensuring the guarantee is meaningful.
Right, that makes sense. Okay, once all these formalities are completed, the bond amount is set, the bonds are executed, sureties, if any, are verified and have made their declarations, the immediate outcome, of course, is discharge from custody for the accused. But there's an important caveat here, isn't there? It's not always a simple get-out-of-jail-free card for everything.
There's a very important caveat, yes, and that's clarified in Section 487. Its core concept mandates the immediate release of a person from custody once the required bond or bail bond has been duly executed. However, subsection 2 clarifies a critical point. Such release applies only to the specific case or matter for which that particular bond was executed. It does not affect detention for any other separate and distinct legal matters.
Ah, okay. So getting bail in one specific case doesn't automatically get you out of jail if you happen to be lawfully detained or wanted in connection with another completely separate case or investigation.
Exactly that. This is the practical step where an accused person regains their liberty for that specific charge for which bail was granted. The court issues a release order, sometimes called a release memo or parwana, to the jail authorities, who then release the individual based on that order. But the crucial aspect of subsection 2 is that bail is strictly case-specific. A bail order granted in Case 1 does not automatically release a person if they are also lawfully detained under judicial remand in connection with Case 2, an entirely unrelated matter. This provision ensures that bail orders are implemented promptly for the relevant case, while simultaneously preventing any unintended or erroneous release from other legitimate legal detentions. It underscores the precision required in managing an individual's complex legal status when multiple cases might be involved.
Okay. But what happens if a surety, who is initially deemed sufficient and fit by the court, later becomes unreliable or financially inadequate? Maybe they go bankrupt or pass away. Does the court have any recourse then to ensure the bail security remains effective?
Yes, it absolutely does. That situation is covered by Section 488. Its core concept empowers a court to require an accused person, who was previously released on bail, to find new sufficient sureties if the initial ones are subsequently found to have been insufficient, perhaps due to mistake or even fraud at the time bail was granted, or if they later become insufficient. Failure by the accused to find these new sufficient sureties when ordered can lead to the accused being recommitted to jail.
Right. So the court isn't just stuck with the initial decision. It can revisit the adequacy of the bail security even after the person has been released, if circumstances materially change.
Exactly. This provision allows the court to reevaluate the adequacy of the sureties even after bail has been granted and the person is out. Insufficient could mean they were perhaps financially inadequate from the very start. Maybe something was overlooked or misrepresented, or it could mean they became insufficient later. Common examples would be if a surety dies or goes bankrupt or perhaps sells the property they had declared as security. The process involves issuing a process, like a warrant, to bring the accused person back before the court. They are then given an opportunity to provide fresh, suitable sureties. This acts as a crucial backstop mechanism, ensuring that the bail conditions remain effective and the accused appearance continues to be genuinely secured by a valid guarantee throughout the duration of the trial or proceedings. It ensures that the initial grant of liberty remains properly secured. For example, if accused A was released with S as their surety, and it's later discovered that S had provided fraudulent financial documents to the court, The court can issue a warrant for A's arrest. When A is produced, the court can order A to find a new, genuinely sufficient surety. If A fails to do so within a reasonable time, A can be committed back to jail. Similarly, if surety S unfortunately passes away during the trial, A might be required by the court to furnish a fresh surety to replace them.
Okay. What if a surety themselves wants to be discharged from their obligation? Maybe their relationship with the accused sours, or they plan to move away. Is there a legal way for a surety to step down from their guarantee?
Yes, Section 489 provides a specific legal mechanism for exactly that scenario. Its core concept allows sureties to apply to a magistrate to be discharged from their bond obligations going forward. If the magistrate allows this discharge, the accused person must then find other sufficient sureties to replace them, or they face the prospect of being committed to jail.
I see. So a surety isn't necessarily bound for the entire duration of the case against their will. They can apply to withdraw their guarantee under certain circumstances.
No, they're not bound indefinitely without recourse. Sureties undertake a significant legal and financial responsibility, and this section allows them to apply to absolve themselves of future responsibility if their circumstances genuinely change, or perhaps if they lose confidence in the accused, for instance, if they develop a strong suspicion that the accused is planning to abscond. The court, upon receiving such an application from a surety, will typically issue a process, like a warrant, to ensure the accused person is brought before it. Once the accused is present, if the magistrate grants the surety's application for discharge, the accused is then required to furnish fresh security find new sureties. Failure to do so within the time given can lead to their recommittal to jail. This provision neatly balances the surety's right to withdraw from their undertaking under appropriate circumstances with the court's ongoing duty to ensure the accused's presence is secured. It ensures the accused remains accountable even if a surety's commitment changes. For example, if S stood surety for accused A, but later obtains credible information that A is making plans to flee the country, S can apply to the magistrate for discharge from the surety bond. The magistrate would then issue a warrant for A's arrest. When A is produced, S can be formally discharged, and A must immediately provide a new, acceptable surety. If A fails, A is likely to be sent back to jail.
Okay. Now, for those people who find arranging sureties quite difficult, maybe they're new to an area or don't have suitable contacts, is there an alternative to finding people to execute a traditional surety bond?
Yes, the law provides a practical alternative in Section 490. Its core concept allows a court or an authorized officer to permit a person who is required to execute a bond, with or without sureties, to instead deposit a sum of money or government promissory notes for the amount specified in the bond. This deposit then serves in lieu of executing the formal bond. However, this option is generally not available for bonds specifically required for maintaining good behavior.
So if you had the cash or equivalent government securities, you can essentially use that as your guarantee instead of relying on finding someone else to stand surety for you. That seems much more straightforward for some people.
It can be, yes. This offers a practical alternative, particularly for individuals who might have the necessary financial means, but face genuine difficulty in arranging suitable sureties due to various reasons. Perhaps they lack strong social ties in the area. It's a direct form of security. If the conditions of release, like appearance, are breached, the deposited sum can be readily forfeited by the court without needing to pursue a surety. The exception for bonds for good behavior, usually required under preventative sections of the law, is crucial. The logic there is that such bonds emphasize a personal undertaking to maintain good conduct, and the influence of sureties is often seen as a key part of ensuring that conduct, rather than just having a financial guarantee against misbehavior. But for appearance bonds, this provision makes the bail system more flexible and potentially accessible across different economic strata. It ensures that financial capacity can sometimes substitute for social connections in securing pretrial liberty, allowing for a more direct, less interpersonal form of guarantee. For example, accused X is granted bail, requiring a personal bond and one surety for Rs. $20,000 each. If X struggles to find a suitable surety but can afford the amount, X might request the court, under Section 490, to allow a cash deposit of Rs. $20,000 instead of furnishing the surety bond. The court has the discretion to permit this. However, if Y is ordered by a court to execute a bond specifically for keeping the peace or maintaining good behavior for a year, Y generally cannot offer a cash deposit instead. They would need to execute the bond, potentially with sureties as ordered.
Okay, let's unpack this. What happens when a bond is breached? The accused fails to show up or violates a condition. How does the court actually enforce the penalties? This is where the consequences become very real, isn't it?
Absolutely. Section 491 outlines the comprehensive procedure for precisely that scenario. Its core concept details how a court proceeds when a bond, either personal or surety, is forfeited due to a breach of its conditions. This procedure includes demanding payment of the penalty amount specified in the bond, laying out methods for recovering that amount if it's not paid voluntarily, treating it like a fine, and importantly, potentially ordering civil imprisonment for sureties who default on paying the forfeited amount.
Right, so breaching a bail bond has very real and potentially severe financial and even personal liberty consequences, not just for the accused, but especially for their sureties who put their money or property on the line.
Absolutely. The consequences can be significant. Forfeiture typically occurs when bond conditions are clearly breached, the most common example being the accused failing to appear in court on a required date. The court first needs to record proof that the forfeiture has occurred, for example, noting the non-appearance on the record. Then it must issue notice to the person or persons bound by the bond, the accused and/or their sureties, giving them an opportunity to pay the penalty amount stated in the bond, or alternatively to show cause, essentially, to provide a valid reason why they shouldn't be forced to pay. If no sufficient cause is shown, for example, the accused was genuinely hospitalized and couldn't inform the court, and the penalty isn't paid voluntarily, the court proceeds to recover it. The recovery method is the same as used for collecting fines, typically using the procedures under Section 461, like attachment and sale of movable property or action by the collector against a movable property. Now, a critical provision here is the potential for civil imprisonment of a surety for a term up to 6 months if the penalty amount cannot be recovered from them using the standard fine recovery methods. This really underscores the seriousness of the surety's undertaking. The court also retains discretion to remit, meaning forgive or reduce a portion of the penalty amount, even after forfeiture, perhaps if the surety made genuine efforts to secure the accused's presence. Interestingly, the death of a surety before the bond is actually forfeited discharges their estate from any liability under that bond. And subsection 5 simplifies proving a breach for those good behavior bonds. If the person bound by it is subsequently convicted of an offense that clearly violates the bond's terms, like committing assault while under a bond to keep the peace, that conviction itself can be used as proof of the breach. This entire section provides the crucial enforcement mechanism that gives real teeth to the whole bond system. It combines principles of natural justice, the show cause notice, with potentially quite coercive recovery methods, demonstrating the serious financial and personal liabilities undertaken by sureties. The provision for civil imprisonment for sureties really highlights the gravity of their promise to the court. The Supreme Court, in the Gulamedi case back in 1960, emphasized the absolute need for this due process, the show cause step, before compelling payment from anyone.
Wow. So just to paint a picture, if a surety guarantees, say, Rs, $50,000 for an accused, and the accused skips town and fails to appear, that surety could be ordered to pay the full Rs of $50,000. If they can't pay and their property is enough to cover it, they could actually face being sent to a civil jail for up to 6 months. That's a huge responsibility.
Precisely. That is the potential consequence, designed to ensure sureties take their role very seriously. If A is released on a bail bond of Rs 50,000 with S as surety, and A fails to appear without a valid excuse, the court forfeits the bond. It then notifies A, if reachable, and definitely S to pay the Rs, 50,000 or show cause why they shouldn't. If S cannot show sufficient cause, maybe A just deliberately absconded despite S efforts, and S doesn't pay the Rs 50,000, the court can then issue orders to try and recover that amount from S's property, treating it as a fine due to the government. If this recovery process fails, maybe S has no assets or hides them effectively, then the court can order S to be committed to civil imprisonment for a period up to 6 months. However, remember, if S had unfortunately passed away before A's failure to appear, S's estate would generally be discharged from that Rs 50,000 liability.
Okay. Once a bond is forfeited like that, what happens to the bond itself? Is it still valid? And what are the implications for the accused? If they are eventually caught and brought back, can they get bail again easily?
Section 492 addresses that directly. Its core concept states that when a bond or bail bond specifically for appearance is forfeited due to a breach, like non-appearance, that bond automatically stands canceled. It's null and void from that point on. Thereafter, if the person's failure to comply, usually the accused's non-appearance, was found by the court to be without sufficient cause, then that person generally cannot be released again in the same case solely on their own personal bond. The court will usually require a fresh bond, this time almost certainly with sureties.
Ah, okay. So The original bond is wiped out, essentially. And if you've defaulted once without a really good reason, getting bail again in the same case becomes harder. The court will demand a stronger guarantee next time.
Exactly. Forfeiture not only triggers that recovery process under Section 491, but also automatically renders the original bond null and void. It's canceled. Then, for any future release consideration in the same case, if the accused is rearrested, for instance, if the court determines that their previous noncompliance was unjustified or without sufficient cause, they typically cannot expect to be released again on a mere personal bond. A simple promise. The court, having been let down once, will usually insist on a fresh bail bond, this time requiring sureties to provide a more robust guarantee. This aims to ensure better compliance going forward and introduces a clear consequence for unjustified noncompliance. It makes the system stricter upon repeated or unexplained defaults. It tells you that the court isn't going to take repeated non-appearances lightly and will demand a stronger guarantee for future appearances. For instance, if A was initially released on just a personal bond, maybe for a bailable offense, fails to appear without excuse, and that bond is forfeited and canceled. If A is later arrested again in connection with that same case, and the court finds A's previous non-appearance was without good reason, A cannot simply expect to be released again on another personal bond. The court will very likely require A to furnish a proper bail bond with one or more sureties for any future release in that case.
Okay. Now, what if the very basis of the original bond, the surety themselves, becomes unreliable during the case? Not because of the accused's actions, but due to the surety's own circumstances, like death or insolvency. Does that impact the accused's continued liberty on bail?
Yes, it does. Section 493 specifically covers this scenario. Its core concept empowers the court to require a person who was previously released on security, i.e. with a surety, to furnish fresh security if their original surety becomes insolvent or dies. It also applies if the original bond itself has been forfeited, as discussed under Section 491. Failure by the person, usually the accused, to furnish this required fresh security when ordered can lead to proceedings as if there was an original default in furnishing security, which usually means being committed back to jail.
I see. So the court maintains the right and perhaps the duty to ensure the bail security remains valid and effective throughout the entire proceedings. The guarantee needs to remain solid.
Absolutely. This provision ensures the continuous effectiveness of the security provided for an accused's appearance. Bail isn't a one-time event. The conditions need to remain effective. If a surety becomes legally or practically ineffective, either through death or proven insolvency, or if the bond involving them has already been forfeited, indicating a past failure and cancellation of that bond, the court can demand that the accused provide new, adequate security, usually meaning finding a new surety. Failure to provide this fresh security when ordered is treated much like an initial failure to furnish security when bail was first granted, potentially leading back to detention. This provision safeguards the integrity of the bail system. It prevents the security underpinning someone's liberty from becoming a mere formality or ineffective if circumstances change significantly. It underscores that the responsibility undertaken by a surety is considered ongoing as long as the accused is on bail under that guarantee. For example, B is released on bail with S as their surety. If, during the trial, S unfortunately passes away or is officially declared insolvent, the court, upon becoming aware of this, can issue notice to B and order them to find a new, suitable surety within a specified time. If B fails to find a replacement surety, B may be committed back to jail until they can comply or until the case concludes.
Okay. We touched on this briefly earlier, but what about specific considerations for children when it comes to executing bonds? Do they have to execute a bond themselves, like an adult would?
That's a very important point addressed by Section 494, which makes a special child-sensitive provision. Its core concept states that if a child, defined legally, often meaning under 18, is required by a court or officer to execute a bond for any purpose under the code, like for appearance, the court or officer may accept a bond executed solely by a surety or sureties on the child's behalf in lieu of requiring a bond from the child themselves.
Ah, so that recognizes the limited legal capacity of a child to enter into these kinds of binding undertakings. That seems very sensible and protective.
It does. This provision explicitly recognizes the limited legal capacity of children to fully understand and enter into potentially complex financial or contractual undertakings like bonds. It allows the security requirement, for instance, ensuring a child witness appears in court, or even if a child accused is released to be met through adult sureties, like parents or guardians, executing the bond. This protects the child's legal interests while still ensuring procedural compliance. It aligns perfectly with broader principles of juvenile justice and creating a child-sensitive legal process. It highlights a compassionate and pragmatic approach within the law, recognizing the unique vulnerabilities and different legal status of children interacting with the justice system. It's a small but significant detail that helps humanize the process for younger individuals. For example, if a 14-year-old child, perhaps a crucial witness in a case, is required by the court to give a bond guaranteeing their appearance on future dates, the court, using Section 494, may readily accept a bond executed by the child's parent or legal guardian acting as surety without requiring the child to execute their own personal bond, which they might not fully comprehend.
Okay. Now, since the penalties for bond forfeiture, as we discussed under Section 491, can be quite severe, significant financial loss, potential civil imprisonment for sureties, is there a right to challenge these forfeiture orders in a higher court?
Yes, there is, and it's a fundamental aspect of ensuring fairness in this process. Section 495 provides a clear right of appeal. Its core concept grants a right of appeal against all orders passed by a magistrate or a court of session under Section 491, the section dealing with the procedure when a bond has been forfeited.
Right. So if you're an accused person, or perhaps more likely, a surety, and you believe a forfeiture order against you is unfair, unjustified, or the amount demanded is excessive, you have a clear legal avenue to appeal that decision.
Exactly. An order forfeiting a bond and demanding payment of the penalty can have significant financial consequences, and as we've seen, could even lead to civil imprisonment for a surety if they can't pay. This section, 495, ensures that such potentially harsh orders are subject to appellate review by a higher judicial authority. This provides a crucial check against potential errors in judgment, misapplication of facts, or undue harshness by the initial court. The appeal lies to the sessions judge if the forfeiture order was passed by a magistrate. If the order was passed by the court of session itself, perhaps in a more serious case it tried, the appeal lies to the high court. This right to appeal is a fundamental safeguard of due process. It ensures that these decisions, which involve significant financial penalties and potentially impact personal liberty, are not immune from higher judicial scrutiny. It helps prevent arbitrary or erroneous enforcement of forfeiture conditions. For instance, if a magistrate, acting under Section 491, orders surety S to pay penalty of Rs. 50,000 following forfeiture, and S genuinely believes the forfeiture itself was unjustified, maybe there was sufficient cause for the non-appearance, or that the full penalty amount is excessive given the circumstances, S can file an appeal against this order directly to the sessions judge under Section 495. The Supreme Court, in the Muhammad Kunju case back in 1999, affirmed the appealability of such forfeiture orders.
Okay. Finally, just one last point on bonds. For bonds that were executed directly before the higher courts themselves, maybe an anticipatory bail bond before the high court, or a bond for appearance during an appeal in the sessions court, how are the forfeiture amounts levied if those bonds are breached? Does the high court or sessions court handle the collection process directly?
That's addressed by Section 496. Its core concept empowers the High Court or a court of session to direct any magistrate to levy the amount due on a bond that was originally executed for appearance or attendance before that specific High Court or court of session itself.
Ah, I see. So the higher courts can essentially delegate the actual, sometimes messy collection process down to a magistrate in the relevant local area. That seems like a practical administrative convenience.
It is, precisely. This facilitates the effective enforcement of bonds that were furnished directly to the higher courts. If such a bond is forfeited by the High Court or Sessions Court due to a breach, that higher court can then delegate the actual recovery process, the levy of the forfeited amount, to a magistrate, usually the chief judicial magistrate or another magistrate in the district where the person or their property is located. That magistrate then uses their existing local machinery and powers, as per Section 461 BNSS, the same ones used for recovering fines, to collect the forfeited amount. This is primarily an administrative convenience for the higher courts, allowing them to focus on their primary judicial functions rather than getting involved in the administrative tasks of debt collection. It ensures that bonds executed at higher judicial levels are just as enforceable in practice as those executed before lower courts, without burdening the appellate courts with the administrative workload of direct recovery. It's another neat example of how the system tries to integrate judicial orders with administrative enforcement processes seamlessly. For example, X was granted anticipatory bail by the High Court and executed the required bond for appearance directly before the High Court whenever required. If X subsequently fails to appear before the High Court on a notified date, the High Court can forfeit the bond. Then, under Section 496, it can issue a direction to the Chief Judicial Magistrate of X's home district, instructing that magistrate to levy the forfeited bond amount from X using procedures similar to those employed for recovering unpaid fines. #, outro and tell it. So, after covering all that detail, what does this all really mean for you, our listener, trying to understand this complex system? We've journeyed today through a really intricate legal landscape within the BNSS, haven't we? From the solemn execution of death sentences with all those meticulous safeguards, to the quite nuanced powers of clemency held by the executive branch, and then finally diving deep into the fundamental provisions that govern personal liberty through bail and bonds.
Yeah, we've definitely seen how this new law, the BNSS, tries to balance so many competing interests: the needs of justice, the protection of society, and fundamentally the rights of individuals caught up in the system. From those striking humanitarian exceptions, like for pregnant women facing a death sentence, to the absolutely crucial credit given for time spent as an under trial. And those powerful, potentially game-changing new victim-centric provisions we discussed in bail hearings for specific sexual offenses. These aren't just dry legal technicalities, are they? They feel like profound reflections of our evolving societal values and the ongoing pursuit of a more equitable and perhaps more responsive justice system.
I think that's right. The BNSS, being a new statute replacing the longstanding CRPC, inevitably builds upon decades of existing jurisprudence. But it also, as we've seen, introduces some very significant procedural changes and important new distinctions. The overall aim appears to be towards creating a more streamlined, efficient, and certainly in some specific areas like victim participation and mercy petition timelines, a potentially more compassionate and victim-responsive criminal justice system. Although how it all plays out in practice remains to be seen.
Indeed. And the level of attention to detail in these sections is quite remarkable, from specifying exactly who issues a warrant to how a fine is recovered across state lines, or the intricate rules dictating how multiple sentences run concurrently or consecutively. It all contributes to building a system that is, at least on paper, striving for fairness, consistency, and accountability. So the big question then is, what does all this mean for the future landscape of criminal justice in India? How might these new provisions, these changes big and small, actually shape the lives of individuals and the day-to-day workings of our courts in the years to come?
Well, it clearly means a new era of legal interpretation and practice is unfolding right now. These detailed procedures, both the protective ones and the punitive ones, will directly impact countless lives. This demands, really, a deeper understanding and careful navigation, not just from legal professionals, lawyers, judges, police, but also from concerned citizens who want to understand how justice operates. The implications of these changes will undoubtedly be felt across the entire justice system.
Absolutely. And that's precisely why these deep dives, trying to understand the nuts and bolts, are so crucial. Thank you for joining us on this extensive exploration of these key chapters of the Bhartiya Nagrik Suraksha Sanhita. We sincerely hope you've gained not just knowledge, but perhaps a new appreciation for the immense complexities, the challenges, and also the vital safeguards woven into the very fabric of our legal system. Until next time, keep digging, keep questioning, and stay well informed.